So, hello everybody. Welcome to another live stream where we can talk about legal wills and any questions that you have related to wills. I'll introduce myself first. My name is Tim Hewson. I am one of the co-founders and I am the CEO of Legal Wills. And we started Legal Wills 25 years ago. And it came about because uh, we realized that none of our friends had wills. We didn't have wills. That's myself and my co-founder, Henry Vowd. We knew that wills were important and other documents like the power of attorney and the living will. Yet nobody that we knew, none of the adults that we knew who had children, who had assets, who had jobs, had got around to writing a will. So it got us thinking back then, back in 2000, 2001, that there's a problem there. There were barriers that weren't being addressed. And back then, people said 65% of adults don't have a will. And that number's really not fundamentally changed very much in the years that have followed. We're still about two-thirds of adults don't have a will. Most people know it's important. And of those that do have a will, many of them are not kept up to date. So we created a service, Legal Wills, and it does two things. Like, first of all, it does remove the barriers. It does make the process more affordable and certainly more accessible. You can write these documents from the comfort of your home. It doesn't take too long. So if you had young children, you can put them to bed and just get your will done. You can do it when the moment strikes. That could be before you're going on vacation, or if you're going to a hospital, or just when you feel like um, you should be an adult. Or more commonly, when people have experienced what it's like to deal with an estate where there was no will. And many people come to our service and saying, you know what, my father recently died, and I am never going to put my family through what I've just been through because my dad didn't have a will. He thought it was obvious what was going to happen, and it was a nightmare. So I'm just going to do the caring, loving thing for my family that my dad didn't do for us. And just I'm going to take the half an hour to get the will written, just to make it a more comfortable process for my loved ones that I leave behind. So, with that being said, I'm going to do a standard introduction to just to say, not a lawyer. I cannot give you legal advice. By all means, please ask questions in the chat. I am going to get to those questions and do them, but I can't give you legal advice, nor can I give you estate planning advice. So tax optimization, ways to structure your estate, things like that. I can't do that. But what I can do is I can give you information about um, how to use our service, what happens if you don't have a will, and general guiding principles for the importance of putting these documents in place and and trying to demystify the process a little bit, because when you do write a will, or power of attorney or a living will, there are a lot of terms that come up that we just don't use in everyday language. Um, Things like executor and beneficiary and trust, and we don't think about those, or know exactly what they mean. And actually, in these legal documents, they mean very, very specific things. So what we do illegal, we try and demystify the language. We try and make knowledge accessible. And so if you are encountering some of these terms for the first time, you can ask us without feeling ignorant, because we're not dealing with this. I know a lot about wills. I don't know much about other things that I don't deal with on an everyday basis. So we don't guard that information, and we're very happy to help people navigate all of the documents and all of the services that we provide. So please ask questions in the chat. I'm just going to have a quick look into the chat, but I'm going to answer one question because it's come up over the last couple of days. Um, and it ties in a little bit with the introduction that I've just given there. So customer support, and how do we handle customer support at Legal Wills? And the reason I'm bringing it up is twofold. One, that I don't know whether our customer support was fully optimized this particular week, and I want to be clear on what we can and we cannot provide. So, if you prepare a document using the services at Legal Wills, you step through it, and all the way through the service, we have frequently asked questions. They're the questions that everybody's going to think about or consider when they're on that page. And that would be a question when you get to, for example, the guardianship for young children. And it's going to be a very common set of questions. People are going to say, well, um, can I name different guardians for my two children, or can the executor be a guardian? Does the guardian have to live where I live? So there are a series of questions that people are going to encounter, um, or think that page. So we try and address those directly on the page itself. And when you step through the service, on the left hand side, you're going to see a series of frequently asked questions, and there's also little question marks next to each field as well. So, for example, on the executor page, a lot of people ask, can I name joint executors? And do I have to name a backup and things like that? So we will address that on the service. So the next level of support, we do have a chat bot in the corner where people can ask it questions, and it's driven by AI. So artificial intelligence is the buzzword, everyone's talking about it, but it's not a standard AI tool. It's not like going to a standard chat GPT. We've trained this text chat bot with all of the support tickets that we've been answering over the last 25 years. And we've trained it on all of the content within our website. So if you had a question about a section within our service, or a question about our pricing, our packaging, things like that, that chatbot is going to be able to answer it. So people say, well, why are you using AI? And it's simply because we do get the same questions coming up very frequently, and trying to address those questions all on the website is impossible. There's too much information there already. So we do have this chatbot that can answer the questions that come up time and time and time again. Um, so the next step after that is, some people just don't like typing. They don't like doing the chatbot. They would prefer to call in and speak to somebody. So our first level support is, once again, it's an AI front end voice agent. And again, they're trained on all of our services and all of our database, and they can answer questions specifically about our service. If that doesn't work for you, you can absolutely email a support ticket, come in, and that support ticket will be answered by a human being. So you can send in an email, and we have bilingual customer support team answering support tickets. The important point about that is that by doing that, we're able to direct the question to the right person. So if you had a question, for example, about um, pricing and packaging, or a question about can my executor be out of my jurisdiction, or I can't get it to display properly on my screen. These are three very different types of questions. And we get some people who can answer the more legally type questions. Some people can answer a specialized specialist on the service, and some people are more kind of tech support. So we have different types of people answering different types of questions, and we have to get the right question to the right person. Um, so the support tickets are answered by real people. And if none of that is working for you, you can book a call, and you can book a call, and somebody's going to call you back, and you will speak to a live person. So we are trying to manage the questions coming in a tiered way, but we will always make a live person available to you, certainly through the support tickets, but also through a live call if you book it. I also happen to know, and if there's anybody on this call, that this week I know that there were a couple of people who did book live callbacks, and we had some staffing issues, and not everybody was available when they were supposed to be available, and some people didn't get called back. 99 times out of 100, that's going to work perfectly. It didn't work perfectly this week. So I just wanted to give an overview of how we answer questions. The important point about that is that we can't answer legal questions. We can't give you legal advice. We can't give you estate planning advice. We can only give you information about our service or generally available information about these documents. So I hopefully that was a long preamble, but I wanted to get into that. Okay, so let's get into it. Can I use the package that I bought to do a will for my friend? Um, so we sell our services to a number of different avenues. You can actually buy activation codes for our service on Amazon. Um, so you can buy our services not directly from us, and there are certainly a lot of partner organizations who partner with us, who do allow you to buy a package to redeem an activation code to redeem on our site. So if you've purchased our services and not used an activation code, absolutely you can pass that activation code on to anybody. We also do gift certificates. So if you wanted your adult children, for example, or your parents, and they've not got around to writing these important documents, you can give them that nudge and you can buy gift certificates, and that would allow them to go on to the service and use that gift card and not have to pay themselves. So we do provide that option. If you've created an account for yourself, the account name on the account is the name that's going to appear in those final documents. So if you create an account for yourself in your name, you're going to be creating documents for yourself. You can certainly create an account for somebody else, like a parent. You can set up the account for your parent, use your own email address, create a user ID and password for them, and then give them the login credentials, and they can step through the service after you've already set up the account for them. Absolutely, you can do that. So yes, if you've purchased our service and not used a code, you can pass it on to somebody else. If you've set up an account for yourself and it's in your name, the documents are going to be in your name. Now, it does happen that people say, "Oh man, I was supposed to be doing this for my sister, and I've set up the account in my name." You can change the name on the profile, so that the documents will be in their name, but you can only do that once, because when we first allowed people to do that, we had some rascals going in there and keep changing the name, changing the name, changing the name, and creating 20 different documents under the same account. So we had to put some restrictions around that, and you can change the name on the account once, and then you can create documents for that person. It also happens that people will set up the account in the name of Bob Smith, and they're like, well, actually, I should use Robert. My proper name's Robert. And you can go in and you can certainly make that change on the profile to make sure that the documents are in the correct name. There's another one that's come in here. I have assets in 2 countries. Can legal wills cover both? Or is it only legitimate to Canada? This is a really interesting question, because some people, they do get confused about their citizenship, um, their residency, where they live, uh, and ultimately, this is the question. The question is really, where are your assets? So your citizenship doesn't actually play into this very much, and even where you live doesn't play into it too much. But if you have assets in multiple countries, we recommend that you prepare a separate will for each country in which you have assets. Uh, it is it is kind of possible, and I have heard of a concept of an international will. We don't buy into that too much, because if you imagine the opposite, and somebody was in Sierra Leone and they prepared a will under the laws of Sierra Leone, and then tried to submit that will to an Ontario probate court, it's not going to be accepted. So switch it around, it's not going to work the other way around either. So that's why we say write a will for each country in which you have assets, and each one of those wills is going to deal with the assets in that jurisdiction. And then it can be submitted through probate or whatever that equivalent process is in that country. So at Legal Wills, we're kind of in a unique position because we have a Canadian service, a US service, a UK service, and a South African service. And what we've done is we've adapted those services to actually allow you to create what we call an expat will. We just called it an expat will, but it's really a will that's written specifically to cover assets in that country and nothing else. It's not interfering with any other will that you might have. So you can, it's very common in certainly in Canada, that somebody could be living in Canada, it's their main residence, but they bought themselves a condo in Florida and they want to have a separate will to cover that condo in Florida. And using our service, absolutely, you can. You can create your main will in Canada. That's going to be your same as everybody else's will, but then you're going to create a separate expat will specifically for your US assets in Florida that's going to deal with that condo. So, yep, create two wills. You can do that using legal wills as long as the assets are in the UK, South Africa, US, or Canada. One other slight wrinkle or a slight expansion to that is in Europe, there is a law to say that you can um, write a will under the laws of your citizenship or nationality to apply to your assets in an individual country. It's a law called Brussels 4. It was passed probably about 10 years ago now. And we actually support that through our UK service. So if you did have assets in Portugal, you could actually use our UK service to cover those assets. And an extension, and this is going to. So, what about China? China, no. So, outside of those countries, no. We don't know the laws of every country in the world, and we strongly recommend that you would go and speak to a legal professional in each of those in the country where your assets are, if you're one of those key countries that we cover. We do partner with one other service provider in India. If you had assets in India, we partner with a company called Will Genie, Jini, and they do a service like ours, but for Indian residents and Indian assets. Right. So once the wills are signed and witnessed, do I have to forward the signed copies to your team? Absolutely not. So we do not store physical documents. It's not a business we are in. We don't even want to be in that business ever. But there are some independent third party service providers who have fireproof, floodproof vaults that store documents. But that's not the business we're in. We generally say that the only person who needs to know where your will is your executor. That's it. So you've named your executor. You've got to let that person know that they are appointed as the executor, and you have to let them know where that document is being stored. The obvious vulnerability is if there was a house fire and you succumbed to a house fire. Well, chances are your will is going to go with you if you stored it in your house. So we recommend that you give it to your executor in a sealed envelope. Ask them to look after it for you. And if something were to happen to you and there was a house fire, your executor is going to have the document. If thinking about it, the executor's house burns down, you can write yourself a new will. But yeah, keeping it outside of where you're located is often a good idea. But most importantly, the executor knows where it is. There's one slight addition to that answer is that there are some forward-looking jurisdictions like BC in Canada and about 10 US states that do actually allow for electronic storage of documents. So you could actually electronically store it. We offer a service called the Vault, and you can store an electronic version of that document in your vault, and your executor can be set up as a key holder who can then log in and access that electronic version. Any other, if you're outside of that jurisdiction, you can actually scan your document and upload it as well. The challenge with that is that an executive really needs to work with the original document that is signed in ink, wet signature on that document, and they could work with a scanned or copied document if it can be proven that the original was accidentally lost or destroyed. Now, there's always the presumption that the testator, you, intentionally destroyed it. So they have to overcome that. They have to say, well, no, this was not an intentional thing. It was accidentally destroyed, and we're going to use the copy instead. That's a process. That's a court process. It's a judge making that judgment. It's a hassle, and it's going to slow everything down. So the definitely the executor should be working with the original signed ink document. I'm going to touch on this one because this one's the estate planning question. Like, what can I do to structure my estate in a way to avoid probate fees? Um, so, first of all, there's a lot of misinformation about this, and particularly there's information that's published a lot for US sites and US services that give people advice on, for example, setting up a living trust and ways to get all of your assets out of your estate so it's not subject to probate fees. So you have to be very careful. Um, I'm just seeing a comment coming in about not being able to understand me, but I'll I'll try and speak slower. Um, so um, Uh, so there's a lot of information out there. So if you are looking for a ref, you have to make sure that if you're in Canada, you're reading a Canadian article, and if you're in the US, you're reading a US article, and obviously the UK, and by extension, wherever you happen to be, make sure you're reading articles pertinent to where you are. It's very, very different. Tax structures are very different. Estate planning techniques are very different. Um, so I can't give estate planning advice, but there are three. I think there's three key points to make here. Firstly, check what your probate fees are in your province or in your state, because it might actually not be that bad. Um, Certainly, Alberta is a fixed it's a fixed amount. It's like a few $100s. It's not that scary. Ontario is a bit different. It is scaled, and we do have a probate fee calculator. In Ontario, it's called estate administration tax. It's a legit tax, um, but it may not be as punitive as the work into trying to avoid it. So just at least look into that first before you jump through hoops to avoid it. Um, there are two key things you can do to avoid probate fees in general terms. Not giving anybody legal advice here, but you want to make sure probate fees, certainly in Ontario and other jurisdictions, are charged on a scale based on the size of your estate. So fundamentally, what you're trying to do is reduce the amount of assets that are in the will that are going to be subject to or triggering these fees. And so when you die and the size of the estate that's covered by the will is calculated, if you can minimize that, then the associated fees are going to be less. So, what are the ways that you can minimize this? Well, first off, you can put things into joint names that where if you die, the joint asset holder will receive that joint asset. And the obvious one here is a home. Like if you own a home and it's jointly owned, then as joint tenancy specifically, then it will flow to the joint owner of that property. It's not going to be part of the calculation for the probate fees. Um, the other one is putting designated beneficiaries on particular things, like a life insurance policy or a registered savings account, like an RSP. You can name a beneficiary on that specifically. And if you do that, then the asset's going to go directly to that beneficiary, and it's not going to be part of the estate that's covered by the will. That's like a 1 minute overview of the kind of things that you might be able to do. But people go to school for a long time to really figure out strategies for minimizing the impact of these probate fees. So there are things you can do, but speak to a professional for doing that. Um, and if I just have a quick look here, um, I bought a package that includes 3 wills. How do you access the will for a friend? Okay, so a package that includes 3 wills. I don't know what that package would be. We generally sell um, wh- one person needs a will. A person won't need multiple wills. They do have a will, a power of attorney, and a living will. That living will is a healthcare medical directive. So we consider those 3 documents to be your complete set of documents. If you have 3 wills, then presumably that's 3 activation codes that you have, and you can pass that activation code on to somebody else who can then go directly to the website and redeem that activation code. So, do my spouse and I have to prepare a will together? Because I want to write one, but I cannot convince my spouse to do it. So this is a this is a really interesting question. So we sell couples packages. So we allow you to buy a will for 49.95, a couples package 79.95. And one of the things that that couples package allows you to do is prepare what's known as a mirror will, where you would name your beneficiaries. And typically, you name your spouse as your main beneficiary, with a plan in case something were to happen to both of you. And then your spouse would do the opposite. You're their main beneficiary. And we have a 1-click mirror will service where you can create your will and then very quickly create the second person's will. So, what happens if the other person has no interest in preparing their will? So, there are a couple of things that you really do need to coordinate on. Uh, the most obvious one is if you have children, your will allows you to name guardians or a guardian for that child or children. So, if you have written a will and you've named a guardian in your will, then certainly if your spouse is also preparing their will, that needs to be coordinated. Don't You can't both be naming 2 different people as your children's guardians if they're both your biological children. The whole point of naming a guardian is so that there's no confusion and no conflicts between loved ones after you've gone, to make sure that you've left clear instruction. So that needs some coordination. But if your spouse hasn't written a will, then your guardianship appointment would be the direction. And if you're both in an accident at the same time, at least you've written a will. There's no benefit to you waiting for your spouse to be ready to write their will, get yours done. So at least there's a guardianship appointment in there. It also allows you to set up trusts for pets. And it also allows you to create charitable bequests, and have a distribution plan for your your assets. I would say absolutely don't wait for your spouse to be ready. They may never be ready. They may be just born irresponsible. Bad luck. But get your will written. But maybe talk to them about, hey, these are all the things that I've covered. You might want to think about doing your will too. And if they say, well, look, I'm only 32 years old, why would I need a will? A will is not written once in your lifetime. It's written when you're an adult. As soon as you feel like an adult, then you write your will and you update it throughout your life as your circumstances change, or anybody named in the will when their circumstances change. It's a document that should be reviewed every year or two throughout your life to make sure that it does reflect your situation and your true values and wishes at that time. So in this particular situation, I would say write your will. Um, Tell your spouse what kinds of questions were asked when you step through the service, and ask them why they don't care about where their things are going and who's going to be the guardian and who's going to look after their pets, and why they don't care about setting up trusts for young beneficiaries and things like that. And maybe that will prompt them. The other one, of course, is the executor. Oftentimes you would name each other as your first choice executor, and then naming a backup. So ask them why they don't really care who looks after their things after they've gone. Just also keep in mind that you've done your spouse a massive favor, and your spouse is doing you no favors at all, because they are leaving you with a disaster, and you're leaving them with a package with a ribbon and a bow. So yeah, I would. It's a kind of a selfish act to decide not to write your will, and hopefully you can convince your spouse of that. I'm just going to do one more question that's just come in. I haven't even read it yet. Compared with a written will drafted by a lawyer and an online self-serve will like legal wills, they both have their own advantages and constraints. Could you talk about them and help make a choice? Yes. So this is going to be the final question because it's a doozy. Um, So most people don't have a will. Um, we've made it available. We've made it very accessible. You can go online. You can prepare your will. We use in our wills the same legal clauses that most lawyers would use when they're preparing a will. So certainly, if you went into a a lawyer's office who didn't necessarily um, didn't have an expertise in wills and estate planning, your will is not going to look any different. If you prepare a will with us, it's going to be word for word identical. Um, what we don't give you is legal advice. So if you had questions about your situation and you weren't sure how the law pertained to your situation, you need to speak to a lawyer. And you need to speak to potentially a will writer who's going to say, there are things that you can do, back to this estate planning idea, to make sure that the mo- um, more of your assets go to the people that you want it to. There's things that you can do to structure your estate. But when I say that, that's like high end. That's a high end lawyer who's going to do that kind of work for you. If you're going to lawyer where they ask you to fill out some forms, and they put it into some software and give it back to you, that's going to be exactly the same as going through a legal will service. So it depends. If you have a good relationship with a lawyer, and it's a lawyer that you trust, and you know they have expertise in wills and estate planning, and you have assets that are complex in different areas, and you want to talk to that lawyer about the different assets and how that should be structured, there's certainly value in what the expertise that that person can give you. If you're sure of how you want to distribute your estate, everything to my spouse. If my spouse dies the same time as me, then everything divided between my children. My assets are not that complicated. Then you may be overpaying, in my opinion, if you go to a lawyer, and a service like legal wills would absolutely be suitable to you. We actually do have lawyers who direct their clients to legal wills, because they feel that our service can service that individual based on their needs and the complexity of their estate. So it's a long answer. I hope it helps, but it does require a little bit of self determination. Like get a look at the complexity of your things, and your assets, and a little bit about the complexity of your family situation. If you had children that are estranged, being disinherited, if you want to disinherit your spouse, clearly things are like, I'm not going to be doing. I need to check with someone whether this is allowed or not. That's what there's. That's why we have lawyers who can help you with that. So, with that, hopefully is helpful. We've kind of come to the end of the time allocation. Um, Please, if I haven't addressed your question, my email address is right there. You can get in touch, tim@legalwills.ca. I do answer every question that anybody sends in to me that I haven't managed to cover on this webinar. Very happy to answer any questions. So I apologize if I didn't get to yours. And if you still need an answer, you can of course, go to our support at Legal Wills team, or you can email me directly, and I'll be very happy to help. So with that, thank you so much for joining again. And I think we're going to do another one of these in a couple of weeks' time. I hope this was useful and helpful to everybody. Thank you.